This is the review lecture for Module 8 on equal protection. When we say equal protection, remember we're referring to civil rights. Equal protection is protection from laws that treat groups of people differently. And we see the original protection for civil rights, for equal protection, is in the 14th Amendment, where it reads, nor the state may not deny any person within its jurisdiction the equal protection of the laws. But since the ratification of the 14th Amendment, we've had several laws passed by Congress and by state legislatures, civil rights legislation, that is more commonly used for the protection of civil rights. When the 14th was first ratified, it was intended to ensure that former slaves were given equal protection by state laws. But it's been extended to require even the national government to apply its laws equally and to protect other, what they refer to as discrete and insular groups, including ethnic groups, women with legitimate children, and even non-U.S. citizens. Courts will review laws that classify people based upon physical characteristics to determine whether they reflect something called invidious discrimination. Governments can treat people differently. That's my point there. There are only certain discriminatory laws that are prohibited as invidious discrimination. Invidious discrimination just means discrimination that's based upon ill will or hatred towards a specific group, particularly race. And what is considered invidious discrimination has changed a little bit over time. And the example given for that is the separate but equal doctrine. That comes from, as you know, the decision of Plessy versus Ferguson. But in the Brown versus Board of Education decision, that policy was struck down. So in 1954, it was recognized that that separate but equal doctrine was, in fact, invidious discrimination and not allowed under the Equal Protection Clause. But in certain circumstances, separating groups of people is justified. However, with race, that separation was motivated by ill will and prejudice and the exploitation of power over an oppressed and disenfranchised group of people. The quality of the services received by the separated races, even if equal, even though they weren't, they were nonetheless illegal because of what motivated those or that policy, that separate but equal policy. And so it was a recognition of the fact that the separate but equal doctrine was actually moved by white supremacists that changed our point of view, or our court's point of view, over what is considered invidious discrimination. Whenever a court is applying the Equal Protection Clause, it's going to consider two things. First, what group is being subject to discriminatory treatment? Because remember, some groups can be treated differently. And then, based upon the group, what degree of scrutiny should be applied? So we're going to start with the first question. Who is being discriminated against? And before I get into that, I want to remind you guys of something that I mentioned in the last module. The court's application of the Equal Protection Clause is sometimes criticized as an unconstitutional judicial activism. This is because to strike down the law, the court must exert power over another branch of government and invalidate the outcome of the legislative process. The people, we the people, right, the citizens, elect representatives who pass laws that reflect the public policies desired by most of the people who elected them. That's the democratic process. And when a court strikes down a law as a violation of the Equal Protection Clause or the Due Process Clause, in both situations, it's overriding the democratic process. It looks like the courts are stepping out of their place and supplanting their own moral beliefs and public policy preferences for those of the people. But, as Justice Stevens explained in the Obergefell decision, The class or group that is disadvantaged by some laws did not have the power to participate in the democratic process that produced the law at its outset. Black people did not vote on the laws that segregated them. Indeed, the laws they were challenging were the very laws that took away their right to vote. And so the court's role here is just to ensure justice. And justice is not upheld when a group of people is oppressed by a law they had no power to vote against. So keep that in mind as we're going through some of these rules and cases. When determining whether or how to apply the Equal Protection Clause, courts are first going to look at the group of people being treated differently. And if that group historically has been powerless in the democratic process, the group is considered a suspect class or a discrete and insular minority. Laws that treat suspect classes differently are strictly scrutinized and very, very likely to be invalidated. Originally, that would have been, they would have just considered former slaves as the suspect class, but as I explained a few moments ago, that determination has expanded to include race, ethnicity, and even national origin. Classifications on the basis of those qualities are motivated by moral prejudices that limited their political power to begin with. And so strict scrutiny is going to apply to those types of classifications. So I guess it tells you that the group that's being discriminated against, that the answer to that question will determine the answer to the next question, which is what level of scrutiny will be applied. The strictest scrutiny is applied to classifications based on race, ethnicity, or national origin. Intermediate scrutiny is applied to classifications based upon gender or legitimacy. Either strict scrutiny or intermediate scrutiny is applied to classifications based upon immigration status. The court has not been entirely consistent in the level of scrutiny applied to that classification. But all other groups get rational basis review. So we're going to look now at just look at these tests a little bit more deeply. We start with rational basis tests. In a rational basis test, the challenger has the burden of proof. So that would be the representative of the group that has been discriminated against is going to have the burden to show that the law is invalid. And here's the test. The challenger has to show, well, it would be the answer to this question is no. Is the law reasonably related to a legitimate government interest? It's the challenger's burden to show that a law is not reasonably related to a legitimate government interest. It's their burden. But the test looks at those two italicized words. Is the law reasonably related? And it's fairly easy to show that it's reasonable. It's an easy burden to satisfy. And then legitimacy. What are legitimate government interests? That means interests that governments have long held, the interest in protecting the public safety, public welfare. Those are the state's police powers. So when the rational basis test applies, it's the law is most likely to be upheld. The opposite is true for strict scrutiny or rigid scrutiny, sometimes referred to as that. And in those analyses, the government has the burden of proof. They must satisfy this test. Is the law necessary to accomplish a compelling government interest? And that's a much higher burden of proof there. Sometimes when a court is looking at a state's law, the purpose of the law may be stated. It may say plainly what it's doing and why it's doing it. Those are laws that are considered facially discriminatory. But sometimes laws are neutral on their face. They don't reference classification or show any evidence of discrimination in the words of the law. However, the state may be applying the law in a discriminatory fashion. So an individual or a group can show that a neutral law is being applied in a discriminatory fashion, or that its application has a discriminatory effect upon a suspect class. And when they do that, then strict scrutiny would apply. And that was the example given for that was the famous Yip Woe decision. I asked you to watch the short video that told the story of Yip Woe and his effort to strike down a law in San Francisco that was discriminating against Japanese immigrants. The once strict scrutiny applies, it is nearly impossible for the government to win. The only time they have actually won, it wasn't a state, it was the United States, the president. And that was in the Korematsu decision involving the Japanese internment order, Japanese American internment order during World War II. That case is an aberration, and it has been overruled. So really, there are no laws that have ever withstood. If you take that one out of the mix, there's never been a law that has satisfied strict scrutiny. Intermediate scrutiny is the last one. And again, the government has the burden of proof here. The test is slightly less strict. The rule is the law substantially related to an important government interest? And it's going to apply mostly to gender-based classifications, although there's been some application of it to immigration status as well as gender. It's just not very consistent. But if you look at the words substantially related, important government interest, sounds pretty ambiguous. And in the end, whether a gender-based classification succeeds or fails kind of has as much to it's as much based on time as it is on legal analysis, because society's tolerance for gender discrimination has changed. And early on, courts saw reason to treat genders differently, and they would uphold laws that treated the female race differently than the male race and then gender, the female gender differently than the male gender. They saw good reason to treat them differently, and they would uphold those classifications. But now in modern times, there's little, if any, reason to treat genders differently. And so even though the court may say we're applying intermediate scrutiny, in the end, these laws are struck down. The analysis is rather strict in the end, the outcomes. The example that we were given in the textbook was the VMI case. And it wasn't just the Virginia Military Institute, it was also involving the Citadel here in South Carolina. There were two cases being presented to the court at the same time, and they involved the exact same issue, whether providing separate facilities for women at these military institutes would satisfy the Equal Protection Clause. And in neither case did it satisfy the clause. The separate facilities were not equal. And the court went through a very factually specific analysis and determined that the VMI and the Citadel had to admit women, that it was their policies were a violation of the Equal Protection Clause. All right, so going beyond the group who is being discriminated against, determines the test or the level of scrutiny that is applied. But you also have to consider who is discriminating. The federal government cannot discriminate any more than state governments can. But there's a little bit of a catch to that. The basis for preventing unequal treatment by the federal government is not the Equal Protection Clause. The 14th Amendment is the only place in the Constitution where equal protection is provided. And the 14th Amendment applies only to states. So for a citizen or a group of citizens to challenge the federal government for civil rights violations, they have to look at the Fifth Amendment's due process clause. And then in reality, they're going to use the federal legislation, laws that were enacted by Congress prohibiting discrimination by the federal government is most likely going to be where they go first. But it's based in the idea of due process. Whenever the federal government denies life, liberty, or property to a group of people based upon their race, their gender, and so forth, it is a civil rights violation, but it is also a due process violation. So in that sense, equal protection is sort of an aspect of due process because it's a group of people receiving a different, perhaps receiving less due process protection than other groups are. They are kind of intertwined, and you'll see them, both equal protection due process challenges, asserted as to the same laws. They're often asserted together. State governments, by the 14th Amendment, absolutely are prohibited. And they take the form often of state action by state legislatures. So if laws enacted by state legislatures treat groups differently, it could be a violation of the Equal Protection Clause if it's invidious discrimination. Actions by state government employees also could be a basis for discrimination. Private individuals, though, are not subject to the Equal Protection Clause. So private citizens can discriminate on the basis of any classification. Now, I have to give you a caveat for that because we have other ways to challenge discrimination by private citizens, and that is through enactments under the Commerce Clause. And if you remember, we talked about that in the last module. The Commerce Clause has been the authority for Congress to enact civil rights legislation that does apply to private businesses. In this module, we are just looking at the Equal Protection Clause of the 14th Amendment. And for the 14th Amendment to apply, you must have state action. So acting alone, private individuals would not be violating the Equal Protection Clause. It's only if agents of the state government are required to enforce the private discrimination. In that instance, Equal Protection Clause does kick in. And an example of that was given in the case of Shelley versus Kramer that's noted in your textbook. No agent or branch of the state government can enforce private discrimination, and in that case, it involved a restrictive covenant. I believe, if I recall correctly, it was a covenant that prohibited selling your home to an African-American family, and that no court could enforce those type of restrictive covenants. I may be remembering that wrong, but look at that case, Shelley versus Kramer, if you want an example of where agents of the state could not enforce private discrimination. Here we're going to look at voting specifically next. The 15th Amendment provides the right of citizens of the United States to vote shall not be, just a minute, shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. That amendment, clearly, as you can see, it applies to the federal government and the state governments. And it formed the basis for eliminating the de jure discrimination in voting that former Confederate states were guilty of. But, you know, it took more than just the 15th Amendment to truly end the disenfranchisement of African Americans. It took the Voting Rights Act, which was congressional legislation that authorized under the Commerce Clause to apply to private businesses and to truly end Jim Crow discrimination in our country. Now, noting that states regulate the voting process, you'll see there has to be some balancing. that goes on with respect to discrimination in voting. States are authorized to make laws that determine the time, place, and manner of even national elections. That's been part of the history and tradition of our country. It is a matter of federalism. But at the same time, states cannot violate other constitutional protections that are afforded to not just citizens, but all people. Voting laws cannot be arbitrarily applied to voter qualifications. Every voter must be treated the same. Voting laws cannot be arbitrarily applied in the counting, the way votes are counted. We saw an example of that in the election of 2000, Bush versus Gore, where the state of Florida was, or the U.S. Supreme Court said, or some majority of the U.S. Supreme Court said that Florida was applying its rules on how to count votes in an arbitrary fashion. Voting laws cannot be used to dilute voting power. And so let me clarify what I mean by dilute. You got to think about a little bit of chemistry. You think about creating a solution, like a salt solution. You could have like a strong, really salty solution, or you could add less salt and add more water. You dilute the solution, okay? That's what I'm talking about. You're taking one individual and diluting their power to elect representatives. I hope that makes sense. I was trying to use an analogy to make that make sense. So first we look at the issue of one person, one vote. I asked you to watch a video that described two U.S. Supreme Court cases, Baker versus Carr and Reynolds versus Sims. And the kind of factual background to this, you should remember from some of your other political science classes that every 10 years we hold a national census. And this national census is used to determine the makeup of representative districts in each state. States regulate the voting process, so state legislatures will decide where boundary lines are drawn for voting districts. And the rule was that the voting districts have to provide equal voting power to all citizens within the district. And it was in these two cases that kind of gives us the constitutional interpretation of that fact. The Baker versus Carr decision said that courts had the power to hear and decide challenges based on a state's apportionment of representation. Before Baker versus Carr, it was considered a non-justiciable political issue that you just had to take up with your state legislature. But in Baker versus Carr, the court found a true private property right involved that could be addressed by the courts. And then subsequently in Reynolds versus Sims, the court held that the Equal Protection Clause requires equal representation in the legislature. So when states go to divide up their representative districts, they have to apportion representation equally so that each person's vote carries the same voting power. The dilution of voting power isn't always just about one person, one vote, though. The Voting Rights Act, for a good bit of time, was a way that minority groups could challenge state laws, including the apportionment of representation in the districts. The Voting Rights Act has been invalidated in part, and so now racial and ethnic minorities have the ability to challenge state laws through private lawsuits. And there's one such private lawsuit currently pending before the U.S. Supreme Court. I asked you to read about it in your reading assignment for this module, Alexander versus the South Carolina State Conference of the NAACP. And they are challenging South Carolina's first congressional district, and saying that the legislature, the way a Republican predominantly Republican legislature drew the lines in such a way to dilute the voting power of African Americans. We'll see how that case comes out, but the point for our purposes in this module is that state laws cannot dilute the voting power of individuals, or, as far as equal protection goes, of race-based groups. In addition to being an issue of equal protection, voting is a fundamental right. So it's protected by due process, and strict scrutiny is going to apply regardless, whether it's an equal protection issue or a due process issue. Strict scrutiny is going to apply to voting laws. So how do you enforce equal protection violations? That's the last topic for this module. Most of the time, as I've said previously, violations of a person's civil rights are addressed as violations of federal civil rights legislation. And so if it's Congress or states that have discriminated against a particular group, you can claim or file a lawsuit as being a violation of civil rights legislation at state or federal level. And the Department of Justice investigates allegations through agency action as well. You can assert a private lawsuit also against government actors based on the 14th Amendment as well. So you have, those are two different ways of enforcing it. You can apply federal laws that are enforced by the DOJ, or you can file a law. So in that case, you would actually go to the Department of Justice to initiate your action. But you can also go to an Article III court and assert a violation of the 14th Amendment or a violation of the Voting Rights Act or some other Civil Rights Act. And then the court would determine the remedy of the violation, which is usually some form of injunction. In the context of education, there is there have been a series of different efforts to try to remediate discrimination, segregation in particular. And I've listed some of them on here. The decision Brown versus Board of Education was in 1954 initially. But then there was a second Brown versus Board of Education lawsuit because states did not immediately comply with the ruling. I mean, states went out of their way to avoid integrating their schools. And so it took a second lawsuit. And even with that second lawsuit, the most that the court can do was issue a judgment saying that the schools were not providing equal protection. Courts are powerless to do anything other than state their judgment. We had to have action by the president, by governors, by Congress, by state legislatures, by local communities to actually enforce, carry into effect those rulings. And what I've got listed here are those very local methods for truly providing integration of schools in particular. And that's busing students from one school to another to try to build diversity, rezoning school districts, giving parents school choice options, and particularly in Greenwood, the magnet programs. They were an effort to provide some assistance with integration. There's a big section in the textbook about affirmative action, and so we'll end with that discussion. Affirmative action is a complicated remedy for equal protection violations because although it is an effort to provide equality, it involves a race-based classification. And that means strict scrutiny applies to affirmative action policies. That's what makes it really complicated. It has this laudable goal, but the means of achieving that goal are strictly scrutinized to the extent race becomes the determinative factor. So you have to look at each case as it has proceeded through the courts. Because strict scrutiny applies, schools bear the burden of justifying their admission policies. So you remember the test for strict scrutiny is the law, or in this case, it would be the admission policy, necessary to accomplish a compelling interest? Well, the school has to show first a compelling interest. And the case law has provided that diversity in education is legally a compelling interest. So you can check the box. There is a compelling interest in providing diversity in education. But the state has to move to the next step. The school has to show, and we're talking about state-run schools, they have to show that their policies are necessary and narrowly tailored to accomplish diversity in education. So as you're reading through the cases, you'll see first an analysis, okay, what is the purpose of the policy? What interest are they trying to accomplish? And schools will go, they'll be more specific than just saying diversity in education. They'll elaborate upon that. So they first must satisfy that. Well, the hang up often comes in tying their policy to that interest and showing that it is narrowly tailored, that it is necessary. They have to show, they have to make the connection very carefully. The cases are showing that, or the cases are suggesting they must always involve an individualized review of applicants. The Bakke decision from 1978, it provides a great deal of analysis and explanation of how the strict scrutiny test will apply. But in the end, the ruling was that admission policies cannot have racial quotas. They can't have a fixed amount of placements for minority groups devoted solely to minority groups. That would be a quota, where race is the absolute determinative factor for these particular seats in their classrooms. The Bollinger decision involves an individualized review that was being provided by the school. And in that case, the court said race can be one among many factors, but they struck down one of the policies, not both of them. They struck down one of the policies for the undergraduate school because it was awarding points to applicants based solely on their minority status. So that was too close to being a quota. But otherwise, I believe it was the law school admission policy that provided a more individualized review, and so it was upheld. Courts are requiring schools to show that race-neutral options would not work. That would be as a part of saying that their admission policies are necessary, that race-neutral options would not work, therefore race-based options are necessary. And it's very difficult to establish that under the current U.S. Supreme Court, which also requires that any admission policy that does provide race-based options must have some sort of endpoint. Their affirmative action efforts can't go on indefinitely. The most recent case involving affirmative action in the context of schools was decided last summer, Students for Fair Admissions versus, in one case it was Harvard and the other it was the University of North Carolina. And both of those policies were struck down as unconstitutional because they lacked they lacked the individualized review. They didn't show race neutral options would not work. They did not have an endpoint. They didn't satisfy those three requirements that fall under that sort of second part of the strict scrutiny test. And a lot of the public criticism of those decisions are that through those decisions, our current very conservative Supreme Court has effectively ended affirmative action in our country. I'm not sure that that is necessarily true. You decide that for yourself, but I'm just telling you what some of the arguments are. Affirmative action policies exist outside the education context. They also exist in businesses as well, particularly government-run businesses. But I just don't have any separate, slide or discussion of it. The rules would be pretty similar to what is applied in the context of education. And I can't emphasize enough that most of the work of providing equal protection is done through enforcement of congressional and state legislation upholding civil rights of individuals. That is the end of the review for Module 8.